recent development within the U.S. legal system, U.S. District Judge Ronnie Greer granted a continuance in a high profile case. Following a motion by defense attorney Mark Brown, this decision came about due to a scheduling conflict with another federal trial in Washington, D.C., which is set to commence on October 28th and cannot be postponed. Originally, the trial in question was scheduled to begin on October 22nd, but due to the granted continuance, it will now take place at a later date. This adjustment was met with agreements from the prosecution, who confirmed that their witness would be available for the new trial date. It is important to note that while the trial date has been shifted, other key deadlines within the case have not been altered. Maintaining the plea deadline on October 8th, such decisions are not uncommon in the judicial process, as they accommodate the complex schedules of legal proceedings and ensure that all parties involved can adequately prepare and present their case. The legal system often requires flexibility to adapt to the dynamic nature of trials and the availability of those involved. Judge Greer's ruling reflects the judiciary's commitment to a fair trial, balancing the needs and rights of the defense with the administration of justice. This case continues to be closely monitored by legal professionals and the public alike, given its significance and the serious nature of the charges involved. Greer referred to a continuance as necessary to allow Mr. Brown to fully prepare for defendant's trial, citing Brown's uncertainty about his ability to sufficiently prepare for both trials in the allotted time. In a case that's already seen numerous delays, he claimed that the factor outweighed the public interest and Williams' right to a speedy trial. On September 12, 2023, Williams, 52, was charged with 3 federal counts of luring a minor to participate in explicit activities with the intent to create child P. A mandatory minimum sentence of 15 years in prison and a maximum of 30 years are imposed upon conviction on any count. Prosecutors claim that there's a photographic proof of Williams essaying 5 children, not just the 3 listed in the criminal counts. In a notice sent out last week to introduce additional evidence at the trial, they stated that because they haven't been able to identify the children, no further counts have been brought against them. However, among other reasons, they wish to use the evidence of the alleged abuse of them because it provides visual proof that Williams is the one who did it. Williams is facing related charges of SA and child art in state court. In addition, he is at the center of 3 federal civil lawsuits against Johnson City and certain police officers, alleging that he AR'd and drugged women in his 5th floor apartment in Johnson City over a number of years ago, and that the police neglected to adequately look into complaints against him in return for bribes. After police attempted to arrest Williams on an unrelated charge in May of 2021, he fled Johnson City. However, on April 30th, 2023, he was taken into custody in Callaway, North Carolina, after allegedly discovering significant quantities of coke and meth on Williams. Authorities allegedly discovered digital files claiming to show Williams barring more people while searching flash drives he carried for proof of drug transactions. In the child P case against Sean Williams, prosecutors are attempting to present additional evidence, including images that claim to depict Williams as saying at least 5 children. Williams' lawyer countered that the evidence was improperly gathered. 5 weeks prior to Williams' scheduled trial, the filings were made. Several laptops, hard drives, and USB drives discovered in Williams' vehicle when he was apprehended in North Carolina last spring, when he was still a fugitive on federal weapons charges, are the source of the evidence, according to court documents. According to documents, the gadgets were housed in a Faraday bag, which is commonly used to prevent radio waves from entering Wi-Fi and cellular networks. More than 100,000 child P photos and videos, many of which seem to have been downloaded from the internet, were found on the devices, according to the prosecution. Additionally, prosecutors claim that there were pictures and video that seemed to show Williams as saying 5 children and 64 different unconscious women at his apartment in downtown Johnson City. According to documents, the files were arranged in a specific folder according to the names of the victims and the acts. The victims were unaware that they were victims until investigators approached them, according to the prosecution. Prosecutors stated they seek to use the evidence to demonstrate a motivation and that the acts were premeditated, despite federal rules restricting the use of evidence unrelated to the offense being tried. However, Williams' defense lawyer contended that the evidence was fraudulently obtained and ought to be excluded. He claimed in court documents that the evidence was gathered during a search of Williams' vehicle without a warrant. According to the petition, the search was carried out when an officer noticed a container containing a white substance while checking on a slouched Williams. Nothing incriminating that was apparent from the case sitting in the passenger seat, according to the defense. The defense also pointed out Williams was not under arrest and had not been read his Miranda rights when he admitted to having drugs, arguing that the statement cannot be used as a cause for a search. That, the defense argued, taints the subsequent search warrants and seizures of evidence. The prosecution's case could be seriously jeopardized if Greer accepts Brown's request to withhold evidence. Federal prosecutors' case heavily rely on the contents of a USB drive that was purportedly found in Williams' car following an early morning encounter at Lena Davis Landing in Colliwaw, North Carolina. Even Brown admits that a search warrant was lawfully acquired a few days after Williams' arrest, and the drive purportedly contains files that show still photographs of Williams essaying 3 separate youngsters on different dates. Brown said that when police found Williams unconscious in a Subaru Baja, they did not have sufficient justification to take evidence from his car. If the alleged narcotics and paraphernalia discovered after Williams' front seat was searched by Officer Charles Gooden at the start of their encounter aren't admissible, then nothing discovered after search warrants have been approved and carried out should be, Brown stated on Tuesday. Gooden claimed during interrogation that he suspected Williams might have OD'd and that he approached his car because it was running and Williams was unconscious in the driver's seat. He claimed he spotted a package on the passenger seat containing many vials, a razor, a butane lighter, and other objects he thought might be connected to drug use or sales after Williams jerked awake. The totality of circumstances, according to prosecutor Emily Swecker, made the search of the front seat lawful because of Williams' state when Gooden arrived. His lack of cooperation, the objects in that seat, and his tense and erratic behavior when Gooden spoke to him. This search was lawful, and he had enough probable cause to search the car based on what he observed, she stated. Brown emphasized how Gooden detained Williams rather than first arresting him or reading him his rights. Gooden stating that when a person demonstrates specific conduct, North Carolina case law permits it. However, Brown pointed out that the trial is subject to federal law. I'm not sure what North Carolina legislation is. That, as the last time I looked, I don't believe anybody can overrule the Fourth Amendment, Brown stated. Greer questioned Brown, who claimed that the first search and seizure was wrong and would contaminate all the others. If there's probable cause for the initial search, there's probable cause for a search warrant, he said. After obtaining a search warrant for the seized vehicle, police allegedly discovered a significant quantity of drugs. They then secured a second warrant to examine Williams' computers and drives, and a third one after allegedly discovering child essay content on the USB drive. The additional evidence request is possible because federal rules are very broad when it comes to cases involving child essay material and as crimes against children. Gomez said prosecutors want jurors to know about thousands of additional child P images found on Williams' devices. They also want to allow testimony about the alleged folders containing video and images of two other children being abused and of dozens of women being essayed. The reason that there aren't charges in the other children's cases is simply because we are working hard to find those young victims, Gomez said. Particularly important, Gomez said, are the videos showing the mothers of the three alleged victims also being hard, apparently while raped. Wow, you guys. The three victim mothers are the priority, and they're embedded throughout the USB drive, Gomez stated, later adding that they were unconscious while the exploitation of their children took place, so they were oblivious of it. This kind of sounds like kids being drugged so they can be sedated and touched, doesn't it? Regarding the evidence she intends to present, Gomez stated, the defendant got access to those children. Here's the proof. She claimed that in addition to demonstrating Williams' propensity for essay, the evidence also demonstrates his lack of mistake, intent, and awareness, as well as a pattern and preparation for the alleged offenses. We will continue to follow the Sean Williams case. His next court date is set for September the 12th. This one, I think, is going to be a doozy as more and more things come to the public's light. This is crazy, you guys. But until next time.
In the shadows, where whispers grow, a chill in the air, something we all know. The ticking clock, it counts the price, as innocence falls, swallowed by vice. Behind closed doors, the darkness crept, a moment of silence where the heartache wept. With every heartbeat, the tension builds,